And I'm your host, Frits Bussemaker, and today I'm delighted and privileged to have a conversation with Professor Teresa Rodríguez de las Heras Ballell. Teresa, good morning.
Thank you. Good morning, Fritz. Very happy to be with you today.
Allow me to introduce you to our audience. You are a full professor in commercial law at the University of Madrid. You're also the Spanish delegate of 2 UN agencies on various projects regarding the legal framework. And you're also a member of the expert groups of the European Commission on New Technologies and Liability. Not only Madrid, you're also involved in a number of other universities around the world, Turin, Austria, Oxford, Tulane. So a very strong and established background. Again, Teresa, welcome to the program. I want to start off with something which made me curious when I read the documentation you sent me in preparation of this interview, and that is about the whole concept of automated decision-making, because that is what has an impact on the legal framework. First of all, before we make assumptions, what is the definition of automated decision-making? What are we talking about?
Thank you. It's a great question because it gives me the opportunity to provide the key elements that are really disrupting private law, thanks to due to the use of artificial intelligence. So we use the term automated decision-making when we are using AI system or any other kind of automation, not necessarily driven by AI, for the purpose of producing or performing an action that is going to be considered a decision with legal effect on third parties. So we are automating a decision-making process. This decision-making could be of any kind. So we could automate, for instance, the decision whether to admit or not a candidate, the decision to promote an employee, the decision by a bank to grant or refuse an application for a loan, or any kind of decision that is going to have an impact in a contractual relationship. For example, the decision to accept an offer and therefore to conclude a contract. All these kind of action have a relevant legal effect, but they have been performed without human intervention at each action that is going to have a legal effect. That would be the general definition of automated decision-making.
Got it. What struck me as curious is that also when you gave a definition of what ADM is, that you make a distinction between AI and non-AI. Is that needed?
It is indeed a very difficult question to answer because there is an interrelation between the technical consideration behind the use of this evolving technology. So to which extent there is a real differences among the different kind of techniques that we could consider under the umbrella of automation, and in particular AI on the one hand. So this is the technological side. And on the legal side, we have to bear in mind to which extent the distinction between deterministic and non-deterministic. So the distinction between those kind of systems that can be learning system, that today we call it AI system, but that could be different in the future. To which extent from a legal point of view, they are different. So to which extent there are challenges that are necessarily linked to the use of AI compared to the use of other technologies used for automation. From a technological point of view, it's probably difficult because there is a range of technologies that are evolving without providing a clear distinction between techniques. All of them probably are considered to be related to automation without human intervention. What we will see probably later is that when we talk about AI, and AI is linked or associated to very specific features. For example, increasing autonomy, for example, opacity, complexity. At a particular level, the legal implication could be different from the implication if we do not use this kind of AI system or this kind of technologies sharing this particular characteristic. So it's indeed difficult because we have to balance the technological complexity and at the same time the legal or legislative reading that we made to that particular technical or technological consideration.
I'm trying to follow this, to be honest, because I was just wondering, you also mentioned that, and I don't know to what extent that's possible, but you're also referring to future technologies. And I'm just wondering if you're going to have like a legal system for each technology category you can, mankind can provide. And
this is clearly the biggest challenge that legal system has to face in relation to technological progress. During the last 2-3 decades, the decision and the policy decision, the fundamental policy decision has been the idea of technological neutrality. So all the law should be designed, drafted, and applied in a way that the technological progress could be embraced properly and sufficiently embraced by any concept or any rule that we include in the law. And that has been working quite effectively and successfully during the last 2 or 3 decades in relation to digital technologies. So we could apply the same rule to paper or to digital format. But now artificial intelligence seems to have shaken this idea, this notion of neutrality vis-a-vis technology. And why is that? Because we have understood AI as entailing impact on the legal conceptualization of many activities and situation and legal consequences so strong, so frontal, that is not sufficient to apply the technological neutrality approach. So in a way, we have perceived a kind of inflection point, something that changed dramatically, so dramatically as to require a specific approach. So a kind of AI specific approach. But of course, this is a challenge, and we have to bear in mind how we are going to handle this challenge in the future. Because as you said, AI is today a technology that we think that we have understood, and we have in a way captured by this AI specific regulatory approach. But what happened in the future? Have we managed to define AI in a way that is evolving, that is going to be open to new technologies? Otherwise, we might be in a situation that is very unfortunate and not very definitely it's quite undesired, because we could be providing different legal rules. That means different legal treatment to different technologies. And maybe that is not sufficiently justified.
Okay, well, I'll come back to later because that's another question I had before. But before I move on to the different legal systems you might be using, we're having this conversation in the context of the Institute for Accountability in the Digital Age. And its background was instigated by UNESCO when the Director Knowledge Societies at the time realized that the technology is moving faster than the legal framework can keep up with. So we have an accountability issue. As a lawyer, as somebody from the legal profession, what's your feel? Can the legal framework keep up with technology? Is that gap growing? And also want to relate it to remark you made earlier, where you said, okay, there's an inflection point, and that almost sounds like, okay, there's a moment in time where we can point to, say, look, that's when the world changed.
Historically, we have always considered that the law should first observe the reality, understand the risk that this reality involved, and only then intervene were necessary. That was the historical understanding of the role of law in any kind of field. However, I have to say that during the last decades, in particular, really after the pandemic, so in the last 4-5 years, we have realized that the law, so regulators and policymakers, have decided to a certain extent, anticipate the potential future implication of technology. So in this regard, I see that this gap is indeed narrowing, is narrowing significantly. And this is clearly not without consequences, of course, because the law needs to understand first how the reality, in this case, the technological phenomenon of AI works, and only then decide whether an intervention is necessary and to which extent and in which condition.
Okay.
If you intervene very early in the market or in the society, of course, you could, in a way, distort how AI could, for example, provide benefits or achieve certain positive goals for humanity. So in a way, the decision of the law or the legislator, the policymakers, to intervene or not is absolutely fundamental in order to mitigate the risk, but at the same time, not to stifle the possible benefits and positive promises of particular AI.
Okay. By the way, the fact you were positive about the fact that the gap is narrowing, which is, I think, very good news for society, because there have been concerns with people that that gap is only widening with all the consequences. And also, I just want to make sure that I understand you correct. I don't know if the COVID period, the pandemic was a coincidence or not, but it almost sounded like that is the turning point. Is that maybe then when we realized as a world, okay, this technology is changing our lives, we have to do something about that. Could we look back? Do you think, or is it too early to tell, that is the inflection point?
I see could be definitely a coincidence, but I don't think so, because the pandemic period entailed a total transformation of our way of living, in a way. And technology played a fundamental role to keep our society and our economy working in pace. And technology proved them that was, on the one hand, essential, but on the other hand, pervading all the society and therefore as well showing potential risk. So I think that pandemic was an inflection point because was the way we get aware that technology was absolutely crucial in the social and economic model that we want to build up in the future. It's not purely an instrument, it's more than that, it's how we shape our society.
And when you talk about our society, the way we view our position to provide a law, uh, do you want to argue that that's a universal perspective, or do you also see, regional cultural changes or differences in how to approach the law?
It's very clear that there are different cultural approaches to how technology can impact on the society, and therefore what kind of society we want to shaped by technology. So there are clearly different cultural approaches. However, I absolutely in favor and advocate strongly for a universal approach. I cannot understand this world anymore with domestic or regional approaches. Of course, I'm not naive. I perfectly understand and realize and appreciate that there are differences that are absolutely embedded in our societies and depend very much of cultural, political, ideological, and many other considerations. But I cannot imagine an approach to AI in particular, or to any other kind of digital technology today, that is not based at least on a universal consensus.
Okay, I'm being devil advocate here. That's your, I would say, assumption, your point of view. Do you see people you interact with have a different point of view? So is your belief for the need for your universal perspective, is that also universal?
Certainly is quite common in certain circles, I can say that. Those who are working for this idea of the international legal harmonization, the idea that there are international organizations that can lead and drive this uniform law for at least international trade. Yeah. But as you said, it's not totally universal. Yeah. And why not? Because AI, as many other technologies throughout history, they also play a fundamental geopolitical role. And once we appreciate that geopolitical role, we realize that technology becomes power as well. And because becomes power, there is a power game. So how you regulate AI, how you promote or how you limit the AI use to a certain extent is going to determine how a particular region is going to play the power position in the world. And that, in my opinion, explain those positions that either because they are very pragmatic or because they consider that technology should be part of this power game in the geopolitical scene, that say, okay, that is the reason why we cannot conceive, we should not think about a universal approach, because AI is part of the power tools that any region can play and can handle in the global scene.
Now, good. I'll leave that for Riz for a moment, because there's a number of other topics I definitely want to discuss with you. But first of all, who are the key players, and who would you consider to be the governing body on an international level to ensure that we have and as much as possible a universal approach to this technology?
That is a fantastic question, because that leads us first to understand how AI can be regulated. So what are the different regulatory approaches? And depending on the regulatory approach, we're going to have different leading actors. So essentially, we have 4 different approaches. The first one is the industry self-governance. So the industry itself decides to self-regulate the activity. Who are the leading actors? The main companies in the world. So we're talking about Microsoft, Google, and many other giant or technological giants that play a fundamental role in the AI development. The second regulatory approach is essentially technical standards based. So the idea is that AI is at the very end a kind of product, so we can mitigate the risk if we established a set of technical standards. So the most important technical standard setters, for example, ISO, among others, are the leading actors in the second approach. The third approach is soft law, essentially promoting and adopting ethical principle, voluntary principle, guiding principle that are not mandatory. They are not binding, but they are in a way crystallizing a consensus of what is good practices, essentially good practices in the AI landscape. Who are the leading actors here? Essentially the UN, UNESCO, as we mentioned before, the Council of Europe, OCDE. They have decided to adopt set of guiding principle or non-binding rules for the purpose of creating this kind of consensus. And the last regulatory approach is hard law, mandatory law. When international organization, the Council of Europe, has adopted the Framework Convention on AI in relation to human rights, democracy, and the rule of law. So a leading actor is clearly the Council of Europe. United Nations, when has decided to adopt, in particular, the model law on automated contracting, is a model law, is not binding, but is clearly a hard law approach. So the model law can be transposed by the state and therefore become law at a domestic level. But probably here, the pioneering and the most important leading actor in the hard law approach has been and is the European Union. The European Union has decided to regulate AI, the first in the world, with the most ambitious and comprehensive approach, the European Regulation on AI, the AI Act. So in this regard, the European Union has become the most important leading actor in order to promote this kind of regulatory approach.
Now, okay, so true. We have the European AI Act, and if I then look where the most organizations are based, for now, let's United States. When I talk to people in the States on this topic, they're very much a proponent of industry-led legislation. So of the four systems you just mentioned, there's also going to be, I don't know if I could qualify it like that or describe it like that, a battle between systems. How are we going to approach this? So of those four, is it going to be a mix? Is somebody going to win? And I have another question for you, which I'll park for the moment. But first of all, of those systems, how are we going to approach that given the different regions and different preferences?
That is a fascinating question because initially we could consider that there is a battle of models. So they are in a way a kind of regulatory arbitrage. And therefore we are going to see, apparently, in the future, which is the model that is winning.
Yeah.
And therefore we could say, okay, definitely in this region, we have higher levels of competitiveness or innovation thanks to a very particular approach. That is probably the most evident analysis of the situation. But I don't believe in that. Or even more, I made a case for a completely different interaction among these different four regulatory approaches. I think that they should be interrelated. They are, there's a feedback, a mutual reciprocal feedback among all these different models. And why is that? First, because AI is essentially global. Any kind of approach that is based on a purely regional or domestic approach is not going to be successful. So we need to use all these different components in order to create a universal regulatory approach to AI. In this regard, I see in particular technical standards contributing to specify what hard law provision states. I see soft law complementing hard law to the extent that it is difficult at the moment to reach consensus of a very particular issue. I see industry self-governance as a way to provide practicalities, to help in the implementation of the hard law. But there's not a real competition. I don't see a real competition anymore to the extent that even in the United States, a big company who decide to expand the business in Europe is going to take into account the European Union AI Act. And that means that it's permeating even beyond the frontiers, the border of the European Union.
Yeah, you see the same with GDPR as an example.
Exactly, great example, yes.
Okay,
yes.
got that. Okay, one of the things I want to come back now, which I parked, and then I want to move on to the liability discussion. But now, so far you've described four models, all how you can approach it from a legal and regulatory perspective, hard, soft, whatever. To what extent is this a 21st century issue which you're trying to resolve with, I would say, predating 19th century approach, the legal system? And do you see a future where we're going to make use of the same 21st century technology to regulate technology? So can technology regulate technology?
Yes, so technology definitely, for me, in the traditional drivers for regulation that so far has been the market. The market is a regulator indeed. The law is the main regulator. And then the social norms. So society is regulator as well. So traditionally, we used to have market, society or social norms, and legal norms as the three main regulatory drivers. Now, technology has become not only an instrument, but a regulator itself. So to your question of could technology be part of the regulatory approach to technology? Certainly, because now it's absolutely impossible to separate, to split our human activity from the variety of technologies that we have already incorporated. So if we are planning regulating AI, we are going to incorporate AI for the purpose of predicting risk. We're going to incorporate AI for the purpose of evaluating risk. We're going to incorporate AI for the purpose of proposing solution. And in a way, we are going to use AI or any other technology as an enforcer. And this is very important because one of the biggest weakness that we have in our regulatory model is that even we have legal rules, we need to make these legal rules enforce. So we need a very strong and dissuasive enforcement system. And this is not always the case. There are many, many weaknesses, a critical point in the enforcement system, but technology is extremely effective for the purpose of enforcement. So definitely technology will be part of the regulatory and enforcement part.
Okay. Today, I mean, time is moving so fast, Teresa. It's a very, fascinating topic, but I also want to spend, because the last part of this conversation talk about what are the topics you're involved in quite a lot, and that is the liability part. So when something does go wrong, who is liable? So how has liability and the liability framework been affected by technology to date?
Let me please start by saying that liability is a crucial component of accountability. Mm-hmm. Because liability, so civil liability, is a very important risk allocating mechanism and incentive allocating mechanism. So for the purpose of creating a strong accountability model, mm-hmm. we need to ensure that the incentive for the purpose of mitigating the risk and preventing damages are allocated effectively and in a way that is proportionate and successful. And this is exactly the role of liability. But liability has been substantially and significantly impacted by AI. We were discussing before, there is a clear difference between AI and non-AI automation. Here, probably we see one of the examples from a legal point of view. AI, or those technologies that we categorize as AI-based technologies, have characteristic or has been understood and described by the law as having certain characteristics that impact on liability. Opacity, complexity, vulnerability, data dependence, and increasing or varying levels of autonomy. All these characteristics are going to impact on the basics of liability. And why is that? Because for the purpose of allocating and attributing liability to someone, we need first to have or to understand who is liable. And in order to do that, we need to understand what happened. So what was the cause? Why this accident has taken place? What was the cause? The data was wrong. The design of the algorithm was inadequate. The passenger committed a mistake. There was a problem related to the functioning or the malfunctioning of the system. Was a third-party interference? Was a hacking situation? So we need to understand what happened. And then we need to connect that what happened, that cause, with the damage. Is what we call the causation link. When the system is characterized by opacity, complexity, vulnerability, that is going to have an impact clearly on how we can effectively understand what happened. If the system is characterized by a certain level of autonomy means a separation, a split between the human control and the action performed by the AI autonomous system. If we accept that, the traditional link between the damage and the person who has in a way contributed or caused the damage is alleviated, is blurring, is becoming less and less easy to be identified. That is the reason why liability has been clearly impacted, clearly influenced by the characteristic of the AI.
I see that the connection between cause and effect is blurred, but at the end of the day, do you always have to be able to hold a person liable, or can you also hold technology liable?
That possibility of attributing the consequences of liability to the technology itself, to the autonomous system itself, was indeed put forward in 2017 by the European Parliament with the idea of expanding the legal fiction of personality to AI systems or autonomous systems. But at the very end, there are many obstacles, impediments that in a way advise against this idea. Ethical impediments. So we are personifying, we are considering that this person is a person, if it's a system. There are many practical considerations, what happens in practice, to which extent we can consider that this AI system has funds for the purpose of compensating, who is going to represent these systems in actions. So there are many obstacles, and probably the effect is not going to be clearly a positive trade-off. Because at the very end, we need, if I may, we need someone responsible for the damage, because this is an incentive, very important incentive allocation effect. Let me explain. If I know as a developer of AI, if I know as the trainer of the AI system, or I know as the deployer of the AI system that I'm going to be liable in case the system causes or is involved in causing damages, I'm going to take measures to mitigate this risk. This is the very important incentive effect. The person who knows and who is in a position to mitigate the risk can do it. That's why it's so important to know who is going to be liable.
Question here, because no, first of all, is this a universal perspective or a more European perspective that you always need a person? Because what I'm thinking of is that there are cases in other parts of the world where an AI engine is granted citizenship. Saudi Arabia, where an AI engine has the possibility to own a patent. Case in South Africa. Not something which is done in Europe, but in other parts of the world, we take a different approach. So what's your take on that?
The liability law in general is probably not as harmonized as others. So we could see, in my opinion, higher level of harmonization at a global level in, for example, contract law compared to liability. And why is that? Probably because liability play a very important role in our understanding of how risk should be managed. So that is the reason why there are different policy options. And exactly you are describing different policies that we can see in the world for the purpose of achieving the goal. And the goal is essentially twofold: mitigating the risk, and when the risk, however, has been materialized and damages have been caused, to compensate those damages in an effective way. So essentially it's preventing and compensating. But the balance between preventing and compensating can be approached from different perspectives. And this is completely true. For example, we see many jurisdictions that have decided to opt for risk-based liability, where we call objective liability. So anytime that you use or you carry out a particular activity that is considered by the law a risk activity, a risky activity, you are liable for any damages, no matter if you are in a fault situation or non-fault situation. In many jurisdictions, this has been the decision for particular the use of AI. Compared to Europe, that has decided, however, to give prevalence of what we call the default model. And the default model, the model that apply always as default, is a fault-based model. So here you can see that there is clearly a disparity between those regions that opt for fault-based compared to those who opt for risk-based. And as you said as well, this idea of extending the fiction of legal personality to AI system is not based on a general consensus. Because of course there are different ways to approach not only the ethical consideration that could be different, but also from a practical point of view, there are different ways to approach the allocation of risk. And one possibility that Europe has decided not to take, but other countries or region has decided to, is precisely to allocate the risk to the AI system and then see what that means in practical terms.
Wow, lots to consider. So it's going to take a while. The reality of that, I'm going to take my Google Maps or any other navigational system to court because I've drove the wrong route. That's not going to happen.
Exactly. So you will always need to identify who was the responsible person behind,
Yes.
who was the closest or the most with most influence on the final impact. That could be the developer, could be the operator, could be the trainer, could be the one in charge of the fine tuning. You have to find who, and this who is not, at least not yet, the AI system itself.
Yeah. Okay. So my final conclusion based from this conversation and all the material you've given me, at the end of the day, the technology is making our life much, much easier, but also more complex to identify who is responsible or not. But at the end of the day, could I argue not that much has changed? We still, at the end of the day, when something goes wrong, we're still going to find who's the person liable for the damage caused. It's just that the route to get there has become a little bit more difficult, maybe.
Yes, indeed. So I think that we are clearly increasing the complexity of our society. Technology is one of the components of this increasing level of complexity, for sure. The law is trying to handle this complexity and at the same time trying to cope with the increasing uncertainty that is surrounding our societies and our economies today. So definitely we need to learn how to not only mitigate, but even assume as a fundamental characteristic of our society today, complexity and uncertainty.
Got it. And at the end of the day, I want to finish with something you presented already in the beginning. You are optimistic. We're closing that gap. And so final question, when are we going to close that gap?
Only to the extent that we manage to devise, invent, develop new ways of regulating. Because so far our law need to find a perfect balance, strike a balance that is not easy between the idea of generality. The law has to be general, not specific. Second, has to be predictable, cannot be a surprise, cannot be unexpected. And third, has to provide legal certainty. So if we need to comply with this, our law cannot be evolving, cannot be changing anytime. But at the same time, the reality is changing very quickly. So we need to find bridges, we need to find mechanisms in order to guarantee at the same time what is absolutely fundamental for providing legal certainty, but at the same time, what is key for taking the pace of our technological progress that is changing anytime and every time.
Good. So I'm still hearing a very optimistic prediction of what the future is going to look like. And I'm pleased to have that story shared with you. Teresa Rodríguez de las Heras Ballell, I want to thank you so much for sharing your insights for the Institute for Accountability in the Digital Age. It's a positive perspective of the world we live in. And I want to thank you for sharing your story.
Thank you very much. It's been a great pleasure to have this conversation with you. Thank you so much for inviting me.
Thank you for listening to the Brand Called You videocast and podcast, a platform that brings you knowledge, experience, and wisdom of hundreds of successful individuals from around the world. Do visit our website www.tbcy.in to watch and listen to the stories of many more individuals. You can also follow us on YouTube, Facebook, Instagram, and Twitter. Just search for the Brand Called You.